If a Virginia police officer smells cannabis during a traffic stop in 2026, can they still search your car? On paper, the answer seems clear. Virginia law restricts searches based solely on odor. But here's the part most people miss: the statute changed faster than enforcement habits did. And that difference determines what happens on the side of the road. Because what the law says, and how it's applied, are not always identical. And we're going to unpack why. Counterintuitive legal fact. Virginia code limits law enforcement from using the odor of marijuana alone as probable cause to search a vehicle. That sounds straightforward. Clear. Protective. But legally true does not always mean operationally complete. Odor alone cannot justify a search. Yet searches still occur. That tension is where confusion begins. Let's challenge your assumptions. Many drivers believe that legalization automatically eliminated vehicle search risk related to cannabis. That belief is understandable. But it assumes something important: that police rely on one factor at a time. They don't. Probable cause, is evaluated under a totality of the circumstances standard. Which means odor might not be enough alone, but odor combined with something else may be. And that something else is where outcomes diverge. Welcome to Norfolk, Virginia Cannabis Hub, where we focus on Virginia-specific cannabis law, local governance, and regulatory clarity, so residents, business owners, and communities understand what the law actually says, not just what headlines suggest. Today we are analyzing vehicle searches, probable cause, and enforcement discretion in Virginia in 2026. This is strictly legal education. No advice on avoiding law enforcement. No promotion. Only statute, enforcement practice, and consequence. Because clarity is protection. Here's the context. Virginia decriminalized and then legalized certain possession of cannabis. Alongside that shift, lawmakers amended search authority related to odor. Before reform, courts routinely held that the smell of marijuana alone created probable cause. After reform, the General Assembly restricted that authority. Specifically, law enforcement may not lawfully search a person, place, or vehicle solely on the basis of odor of marijuana. That is the surface-level rule. But here's where history matters. Vehicle searches operate under what's known as the automobile exception to the Fourth Amendment. That doctrine allows warrantless searches if probable cause exists. So while odor alone is restricted under Virginia statute, probable cause itself still exists as a constitutional standard. And that overlap is where interpretation begins. Here's the legal explanation. Under Virginia law, odor alone does not justify a search. That is accurate. But probable cause is not defined by one sensory observation. It's defined by reasonable belief that evidence of a crime exists. And in Virginia, cannabis possession over legal limits, distribution, impaired driving, and certain packaging violations still constitute offenses. So, if odor is combined with visible contraband statements from occupants' admission of unlawful quantity, signs of impairment, open container evidence, then the search analysis changes. It changes because probable cause is cumulative. Let me rephrase that. Odor may not open the door by itself, but it can still contribute to the key. That distinction matters legally. Now here's the second layer. Even when odor alone is insufficient, officers still initiate investigations based on total circumstances. And courts evaluate those circumstances after the fact. Which means roadside interpretation and courtroom interpretation may not align perfectly. This is where cases turn. How enforcement works. Traffic stops begin for independent reasons: speeding, equipment violations, expired tags. During that stop, officers may observe factors unrelated to the original reason. If an officer testifies that odor was present alongside another factor, nervous behavior, visible residue, inconsistent statements, courts examine whether probable cause existed beyond odor alone. And this is critical. Lab reports are not required before a search. Probable cause is assessed based on reasonable belief at the moment. So even if no illegal quantity is ultimately found, the legality of the search depends on whether the officer reasonably believed evidence might be present. This is where the law says one thing. Enforcement says another. Because while odor alone is restricted, odor plus interpretation becomes something else. Now, this is the turning point most viewers don't anticipate. Many people think the reform eliminated roadside risk. But vehicle searches operate differently than home searches. The automobile exception remains powerful. And impairment enforcement under Virginia DUI statutes creates additional exposure. So even if possession is within legal limits, impaired driving suspicion changes everything. That's where outcomes diverge. Because the law limits one narrow trigger, odor alone, but does not eliminate probable cause analysis altogether. And this is where most people stop learning, and where problems start. Who this affects? Consumers are affected first. Drivers transporting legally possessed cannabis may assume they are insulated from search. That assumption can collapse if additional factors arise. Retailers are indirectly affected because packaging and labeling compliance influences whether visible evidence suggests legality or violation. Local governments are affected because enforcement guidance varies by department. Norfolk may interpret procedural caution differently than another locality. Each category experiences the same statute differently in practice. Why this matters? Public safety considerations remain central to DUI enforcement. Regulatory clarity matters because misunderstanding search authority creates legal disputes. Here's a scenario. Earlier, I mentioned that odor alone cannot justify a search, but that enforcement outcomes still vary. Let's return to that. Scenario 1. A driver in Norfolk is stopped for speeding. The officer reports faint odor of cannabis. No visible contraband. Driver provides valid ID. No signs of impairment. No inconsistent statements. Under Virginia law, odor alone does not justify a vehicle search. In this scenario, absent additional factors, a search would likely violate the statute. Now scenario 2. Same stop. Same faint odor. But this time, the officer observes an open container in plain view. The driver admits possessing a little more than allowed. The officer also notes delayed responses and glassy eyes. Now we have cumulative factors. Odor plus admission plus visible evidence plus potential impairment. That combination may satisfy probable cause. The statute did not change, the surrounding facts did. And that small distinction changes everything. Because probable cause is contextual. It is not mechanical. And that is the silent legal question from the beginning: does legalization eliminate search authority? The answer is no. It limits one trigger. It does not erase constitutional doctrine. Here's what to watch next. In our next breakdown, we will examine how Virginia cannabis DUI enforcement intersects with roadside testing standards in 2026, and whether chemical thresholds even exist. Because impairment standards are evolving, and enforcement interpretation continues to shift. Here's a question to think about. If odor alone cannot justify a search, but probable cause remains cumulative, where should the legal line be drawn? Share your thoughts respectfully in the comments. And let us know what Virginia cannabis legal issue you want analyzed next. If this breakdown helped clarify confusion, consider subscribing. Because on this channel, we separate headlines from statute, and statute from enforcement. Remember, the law says one thing. Enforcement says another. And understanding that difference is what protects you.